Councilmember Burns. Councilmember Sufferton. Councilmember Ravel.
Here.
Councilmember Reed. Councilmember Kelly. Here. Sorry, Councilmember Heracariz.
Here.
Councilmember Nguyen. Yes. Councilmember Nusma.
Here. With 5 members plus me present, we have a quorum and are prepared to do our work. The first item on our agenda is public.
Recording in progress.
The first item on our agenda is public comment. So here's how we're going to do this. The only non sort of mechanical item on our agenda is our ethics training. So we have here our ethics, our special counsel for our ethics committee, Elrod and Friedman, which there's a number of representatives here. We have a number of people who've signed up for public comment, but our ethics council has a hard stop, and also no offense, but they're paid by the hour. So what we're going to do is invite those who came in person to give public comment in person the opportunity to go first, then pause on public comment, go to the ethics training, and then if those who are seeking to give public comment online would like to hang around until the end of the ethics training, they'll be entitled to give public comment at that time. But
apologies, I want to note that we can't hear the council chambers on the Zoom call.
All right, has that been fixed, council member?
Yes, that has. Now I can hear you.
Great. So what I was just describing is that in order to ensure that we can complete our ethics training and also that we are responsible with the city's financial resources, we're going to allow those who signed up to give public comment in person the opportunity to speak. Then we'll pause on public comment, go to the ethics training, and then if those who signed up to give public comment online would like to hang around, they'll be entitled to give public comment at the end. I would counsel those who are contemplating how to spend this beautiful summer afternoon that there will be no substantive action taken by City Council today and no closed session discussions. And so, do what you want to do, but there maybe isn't any kind of urgent need to give public comment today. But we begin with those who signed up to give public comment in person, who will each be given up to 3 minutes, beginning with Jackson Paller.
Thank you, Mayor Biss, members of council. My name is Jackson Paller. I live in the First Ward, and I'm a member of Reclaim Chicago and the Community Alliance for Better Government. And I want to add my thoughts to the cores who I think are going to come behind me later with my concern for the still ongoing search for our next city manager. Now, members of council, while selecting the city manager is your purview, I think that Evanston residents have collectively made it clear that this next city manager needs to not just be enthusiastic about doing anti-racist work, but have a track record of doing it. And we also need someone who isn't just enthusiastic about building trust with residents, but actually has a track record of doing it. And we can't afford to hire someone new who will just continue the failed status quo. Such a candidate could either perpetuate a pre-existing, often hostile relationship with Evanston residents, or could respond to vocal opposition by quitting, which would leave us needing to restart the search process again. And as a city, we cannot afford that. Also, I want to mention that since the last municipal election, I do think this council has made some significant progress in regaining community trust, and I'm excited to see that continue. But if any finalists put forward aren't excited to be collaborative, anti-racist, trustworthy public servants, it would feel like a betrayal and you could lose our trust again, and I don't want to see that. Lastly, although I don't know Luke Stowe personally, as best as I can tell from everyone who I've heard speak about him, he's very highly respected, and I do trust him to continue to do the work of the city while we take the time to do this search correctly. And lastly, I do want to thank Mayor Biss for holding his recent town hall and giving considerate answers to the questions he received. And that town hall did shed some light on the process, but what comes next depends on all of you. And members of council, I hope you will keep these thoughts in mind. Thank you.
Thank you. The next speaker is Molly Hartenstein.
Hi, Council. Hello, Mayor Biss. My name is Molly Hartenstein from the 4th Ward. I'm here on behalf of Evans Fight for Black Lives to also talk with the city manager search. It was really disappointing to hear during the town hall that One of the barriers to actually changing anything regarding policing in this city is a lack of a city manager. And somehow, even though we have hundreds of city employees working around the clock and an entire committee that's been working for 2 years and actually created recommendations, that those things won't be put into place until they have someone to tell people what to do. That makes me question, one, the ability of the council to make change, the ability of the committee for reimagining public safety to make change, and 3, the ability of our city employees to do anything if they are unable to make any substantial change until an entirely new city manager is hired. It's really also disheartening to hear this narrative that public input is not welcome. I think blaming the lack of progress on a city manager is immature and negligent of the other city's employees and elected officials' actual responsibilities. What's really to blame is the city council's lack of leadership, which is especially evident regarding defunding and what I just said that I heard in the town hall meeting the other day. Second, public input is necessary to hold the city and whatever candidates it nominates accountable. This is especially true since the last person nominated by the city for city manager had a track record of racist and discriminatory behavior while serving in public office and was replacing a predecessing city manager who also resigned amid scandals that included racial and gender-based discrimination. This is the bare minimum that we're asking for, and to say that this is asking for too much is really a lot coming from the Evanston City Council. And then third and lastly, the city manager does hold an immensely important role in the Evanston city government and therefore should be exposed to as much scrutiny as necessary. Over a year ago, we met with city manager Erica Storley to discuss the city manager's role in choosing the next police chief, and we demanded that the process for hiring the next police chief be open to the public and be transparent, and that the new chief be knowledgeable about defunding and why it is necessary. Those conversations from us, as well as many other groups and individuals, clearly fell on deaf ears when the decision was made to rehire Chief Eddington, the chief who was fired for the Lawrence Crosby incident, who was fired for being racist and then was rehired. Questions of policing public safety should be central to the city manager hiring process, and the city manager is single-handedly responsible for hiring the next police chief. All of this is gone unaddressed, and the narrative being pushed by the city is really just not true. That is all. Thank you for your time. Thanks.
Thank you. The next speaker is Heather Sweeney.
Hi, my name is Heather Sweeney. I'm in the 4th Ward. City Council Mayor Biss, I'm here to speak about the city manager position. First, I thank you for your service. I don't envy your position that you're all in, and we know this is a challenging situation. I understand there's urgency, understandable urgency to fill this position. And I'm not clear exactly where you are in the process, but as a community member, if a candidate with a strong equity and anti-racist lens, along with a track record of equity and anti-racist action is hired, that tells me as a resident that this council prioritizes operationalizing the values that we purport to have here in Evanston, that this city values all residents and is committed to working for all residents, especially those who have been historically marginalized. When racial equity is prioritized, you tell the community that you prioritize a well-run city and the well-being of all residents. And of course, those two are not mutually exclusive. In fact, they're dependent on each other. So what message are you giving the community about your values, your priorities, and frankly, your competence to be in a decision-making position if you do not prioritize racial equity as an umbrella competency for all candidates?
Thank you. The final speaker for the in-person section of this afternoon's public comment will be Ray Friedman.
Good evening, or good afternoon, City Council, Mayor Biss. First, I have a request, Mayor Biss. Since I've been doing public comment for the last 4 or 5 years, at the beginning of public comment, it was always announced how many people were signed up for public comment. And I think that's helpful, that I think we should all know that at the onset. So my first comment is about the town hall meeting, your town hall meeting last week. I thought the purpose was to hear questions and answer questions about searching for and having residents involved in this process. So I was going to save my public comment for next council meeting, but since you're doing ethics training now, I'd like to read a previous public comment, May 24th, 2021. Thank you, Mayor Biss, for starting your new ad hoc committee, and congratulations on being elected. Your words are very encouraging when you spoke of public input, in quotes, that this work cannot be successful without meaningful and significant public input beyond what's achievable through state-mandated public comment, that's this, sessions at our meetings, and that you would be open to anything, be it town hall meetings, smaller roundtables, distribution of surveys, or whatever would work. End quote. I haven't seen the transparency or the accountability that you promised. Haven't seen any of these public meetings that you promised also. Our next city manager, we understand you chose already. There's no public input. Okay, there was no public input on the $50 million Robert Crown bonds. There was little input on the TIF hearing. Look at the current government structure for City of Evanston. Residents are number one, okay? With no input from the residents and the decisions coming from, I guess, City Council. I mean, I thought this was a perfect time to point out that when do the residents get to speak, get to be part of the process, part of the decision-making process? I've asked for that for 2 or 3 years now. Okay. Lastly, you are purposely keeping residents out of the discussions. A week and a half ago, there was four ward meetings, same night, same time.
Your time is up.
They're not recorded. They need to be recorded so anybody can
Thank you
hear
very
what
much.
happened at the local ward meeting so they know what's going on in the city.
Thank you very much, Mr. Friedman.
You're welcome.
We will move now to the ethics training that is the primary purpose of this afternoon. So take it away, Mr. Elrod.
Thank you, Mayor Biss, members of the Evanston City Council, city staff, Clerk Mendoza. Thank you for having us here, and our interim city manager, Stowe. Thank you for having us here to provide your ethics training. My name is Stephen Elrod. I am the founding partner and the managing partner of Elrod Friedman. And along with me today are Marcus Martinez of our firm and Brooke Lenneman of our firm. Also in the audience is Hannah Syed of our, who's a summer associate of our firm. Thought that she'd be interested in observing. She's still in law school. First, let me say we were deeply honored to have been appointed the city's Special Ethics Council earlier this year, and we have been working with the issues and matters that have come before us. We'll give a little bit of an explanation about that role at the end of our presentation. We have put together this presentation in part because it's required under your ordinance, this training. We are recording it for those council members who are not here today, and for anyone that joins on the city council, you'll now have the ethics training recorded and on your shelf so that you can, so somebody could watch it again, and you're welcome to watch it over and over. We're going to cover 6 major topics, substantive topics: prohibited political activities, the Gift Ban Act, conflicts of interest, official misconduct, and whistleblower protections. Most of those are set forth in state statute. What we're going to do is I'm going to talk to you about what the state requires, and then Brooke and Marcus are going to take that down to Evanston's level, because in many instances, Evanston, in adopting its ethics ordinance, exceeded the requirements of state law. Evanston has one of the strongest ethics ordinances on the books of any municipality that I'm aware, and I represent many different towns in the Chicago suburban area. It's a very strong ethics code, and we'll point out where it where the differences between Evanston's code is and the state statutes are. So, and then after that, we'll talk about the enforcement and the role of the Ethics Council. So that's, and we're going to go through it. If we have time for questions, we're happy to answer them. We do have a limited time period, and we're hoping to accomplish everything within that time period and be done by 5:15. And Mayor, with your permission, we're going to, since some of this is interactive, the three of us are going to make the presentation from the table here. Okay. So I'm actually starting. I'm going to begin with prohibited political activities. We did our best to find some graphics that are interesting, but this is just generic politics. The Prohibited Political Activities Act at the state level covers three essential restrictions. It deals with basically, as the title says, a prohibition of doing political activities during compensated time. Now that's easy for employees. You know what compensated time is when they're basically on the job, although the city manager is typically 24/7. It's a little more tricky with respect to elected officials. What constitutes compensated time? The general rule is that compensated time is interpreted for elected officials as when they are conducting city business and exercising their official duties, regardless of the location. Certainly when they are at City Hall, and very likely when they are in a ward meeting conducting the business of the city. At other times, even if it's during the day, they may not necessarily be conducting city business, so they would not be on compensated time. Different for employees. And then if we just run to the next slide, we'll come back to this. Here are we'll go back. Here are the examples of activities that are specifically prohibited under the State Act. It's solicitation of contributions, circulation of candidate petitions, distributing literature, or wearing a button or on your apparel. So, in its basic sense, a member of the City Council could not wear a campaign button, whether it's for themselves or any other office, while on the dais. And they can't do it while they are I would say generally while they are at City Hall, and they certainly cannot circulate petitions while at City Hall, etc. Back to the slide right before that, the other issue that's covered in the statute is the use of city property or resources in connection with any political activity. You cannot use a city phone, a city email, a city copy machine for political activities of any kind, both at the elected level and at the staff level. And finally, importantly, the city cannot make as a condition of employment the engagement of involvement in political activities as part of the employment contract. That seems somewhat axiomatic in today's era. Believe it or not, it wasn't, and it was necessary for the state to include that as part of a state statute because local governments, perhaps the bigger one directly to the south of us, were hiring people to engage in political activities as part of their payrolled activity. That is now a prohibition. And so now let's see what the difference is in
Prohibited political activities. The regulation for that is set forth in the Evanston City Code, section 110.4, subsection F, and it tracks the Illinois statute pretty closely. The prohibitions that Steve spoke of just now are present in the ordinance. The ordinance does have a slight departure from the statute in that while the statute defines the prohibited political activity, Evanston goes one step further. Their language is any political activity is prohibited, and there are 7 specified circumstances, and these circumstances will seem very familiar when compared to what Steve just described. As we just saw, compensated time, you cannot use city property, you cannot use city resources to conduct any political activity. You cannot participate in any political activity while on compensated time. It's a very subtle distinction, but it's a distinction that the ordinance makes. Prohibited political activities anytime, like we mentioned, you cannot be required to engage in political or campaign activity as part of a job. An employee cannot be required to engage in such activity as a condition of continued employment or advancement, or in exchange for compensation or benefits. Similarly, you cannot award an employee who has engaged in political activities. Lastly, you cannot require a political contribution as part of someone's employment or as a condition of their advancement.
Let's move on to gift ban, which is the next area. Yeah, maybe we can, Mayor, we can take brief questions on each section or at the end. What is your preference?
As long as we're really careful with time, I think it makes more sense to do questions section by section.
Let's go for it.
Go ahead, Councilmember Kelly.
So just to clarify, and this came up in the past, so clearly then an elected official could not use their city email to solicit funds for a cause, correct?
For a
cause,
Well, so here's the difference. If in any other town, I would say cause would have to be further defined as one of the 15 prohibited political activities. It would have to, the state statute has 15 defined prohibited political activities. Evanston says any political activity. So I'd have to look at what the cause is. If it's a nonprofit organization that is not a political cause, there you may be able to use. You may implicate a different issue of private use of city property, but it wouldn't be a violation of the Gift Ban Act. I'm sorry, of the Prohibited Political Activity Act. Okay?
Councilmember Nusma.
Thank you, Mr. Mayor. One very practical question that has come up recently regards a referendum that we have agreed to put on the ballot in November happens to be regarding ranked choice voting. The question has come up, can we as council members campaign for or against that referendum from the dais? I guess not. From a ward meeting on city property? Clearly not. From a ward meeting off property? Or like what kind of guidelines should we impose upon ourselves there?
Referenda has typically created a great deal of consternation under the Prohibited Political Activity Act. The general rule is that no city resources can be used in support or in opposition to a referendum. So the city can't put out literature saying vote for, vote against. But a city can put out, and I'll get to your question, I just want to take it from a higher level. The city can put out general information about, as long as it is neutral information or factual information about the subject matter of the referendum. The debate frequently is, well, how slanted is the language? Are they presenting all sides? The state and the courts have generally interpreted it as it has to be truly over the top in favor or in opposition. If the city is simply attempting in good faith to put out information about whatever the referendum may be, that would probably be lawful. As to an individual council member, I think in Evanston, the broad definition of any political activity would certainly include a referenda that's on the agenda. So during compensated time, if that council member were at City Hall or if the council member were conducting city business, I would say they cannot campaign for or against the referendum. It's hard to, under your code, to truly distinguish when a council member is not conducting city business when they're talking about a referenda that is on a ballot. It's possible if that referenda were not an Evanston referenda, but maybe a statewide or a referendum, that may not be necessarily city business. If it's an Evanston referendum that may have been initiated by this city council, that it may be difficult for a council member to talk about that in campaign for or against it at any time.
Councilmember Nguyen, followed by Reed.
I think you may have just answered my question. So I recognize that we all have regular ward meetings that, for instance, mine are always at Lincoln School, so it's not city property. And I recognize that you cannot talk about this at that meeting because that is specifically a meeting in which I am talking about
City business.
City business.
Correct.
If somebody, for instance, like the League of Women Voters had a meeting and council members were invited, where would that be on that spectrum?
It's a very good question. Are we still talking about referenda, or are we talking about a political candidate?
A referendum.
It's a great question. If the council member were simply providing direct information, the same information that the city itself put out, the council member could distribute that information if it's the same information that was put out by the city. I would be very careful, and I would be concerned, based on your broad definition, of any council member going off script in any direction beyond that which was the city-initiated information package.
So, for instance, if the League of Women Voters asks that, has some forum, and we present just the facts, and we cannot. If someone says, "Do you support this?" from the audience, we can't answer that. Correct?
I would say that could create I mean, you're asking a hypothetical, and I always get careful. I would be very careful in that situation. And when you say just present the facts, I would be careful doing even that.
Okay.
If there is a document, and frequently the city does put out, or cities do put out literature, just factual literature about an item on the referendum that isn't intended to be forward, a pro or con. The mere passing out of saying this is what was created by the city is about as far as you can. I wouldn't attempt to summarize it. I wouldn't attempt to brief it, because you just by the way in which you're presenting it could cause a violation of your own ordinance.
Okay, thank you.
Councilmember Reed.
Yeah, thank you. My questions were, Mr. Elrod, is always, it's always wonderful being in your presence and being educated by you and your team. I wonder, and so a lot of my questions were answered by questions by Councilmember Nusma and Councilmember Nguyen, but in line with that, I wonder how, the municipal code plays into this, being that council's powers are purely legislative. And so anything that we do, I would think outside of the legislative process would not be in our official capacity. Does that sound?
It's an argument, but you have drafted your code provision very broadly. So I would just offer caution to all of you that there could be an interpretation made that you were. Let me get the exact word from you. Yeah. That your conduct could be considered compensated time, and it could be some relationship to the execution of your official duties. I understand that your official duties are purely legislative, but an argument could be drawn that a matter on the referendum matter is a legislative action. So there could be a tie. So I would, my best advice to you is to exercise extreme caution.
Councilmember Burns.
Thank you.
As long as it's not during work hours, could someone that works for an elected official would it be appropriate for someone who worked for an elected official to campaign for them? This is something that wouldn't impact me personally, but I'm curious for my own.
Well, if someone that
understanding.
works, are we talking about a city employee or somebody that?
Correct. Yeah, city employee. Let's start there. Yeah.
Well, there's no prohibition that someone couldn't volunteer their time after hours to campaign for an elected official's election or reelection, as long as it's truly volunteer time. It can't be a condition of their employment or, tied to their compensation, or any kind of requirement, either implicit or not, for working for you. So, but if someone wanted to, after hours, volunteer, on the weekend volunteer, there's no prohibition against that.
Yeah. Okay. That was my understanding. I just wanted that to be confirmed out loud. Okay. And then, secondly, this is more so just getting it on the record now that I have a better sense of what we can and cannot do around the referenda. Before we put out anything about the referenda, we need to be in agreement about what that information is. And I want to get that on the record now. We should not put out anything unless we have all looked on it and it has been voted on by a majority of council. Thank you.
Mayor, I think we should move on to
Let me. I have a question though. I'm actually really puzzled by what's just occurred, and so let me give a different, very plausible hypothetical. It's October, and J.B. Pritzker or Tammy Duckworth has a Get Out the Vote rally in Evanston, off government property, and invites one of us to come speak at that rally. We can do that, right?
Absolutely. As long as you're not conducting city business at that rally, absolutely.
And so the difference between that and Councilmember Wynn's example of the League of Women Voters Forum is the fact that the subject matter of an election of a governor is clearly not city business, whereas the subject matter of a referendum is itself ipso facto arguably city business?
Mayor, that's in her hypothetical, as I understood it, the League of Women Voters was talking about the referendum.
Yeah.
Yeah,
And so your concern here is that as long as we're talking about the referendum, that's arguably city business.
Yes.
Okay. All right, let's move on.
Okay. Next area, and prohibited political activities was supposed to be the easy one, but we appreciate the comments and are happy to answer the questions. We're getting increasingly more complex. Next is the gift ban. Generally at the state level, first, the Gift Ban Act is codified in state law. When it was first adopted about 20 years ago, the state required every municipality in the state to adopt a Gift Ban Act. Most municipalities simply incorporated by reference the state act. Evanston, as we'll talk, has gone a step further. And the state requirement is that you could adopt a Gift Ban Act no less strict than the state one. At the state level, the general rule is that elected officials and employees cannot intentionally, and that's the important word at the state level, solicit or accept a gift from a prohibited source. So the key is, what is a gift and what is a prohibited source? And a gift is any tangible or intangible item having monetary value. It applies to spouses and immediate family members that live with the officer. And a prohibited source are those listed on the screen. Someone seeking official municipal action or business, meaning an applicant, a developer, someone who does business with the city, anyone that has a contract with the city, someone who conducts activity regulated by the city, and someone with interest that may be substantially affected by city action or, importantly, by non-action of the city. There are exceptions, and among those are lawful political contributions that are set forth in the statute, such as gifts from relatives and friends, but not if the official believes that the gift is connected to the official's position or employment. So if a relative is seeking a zoning variation and they give a timely gift right before the vote on that zoning variation, that may be a violation of the Gift Ban Act. But if the relative gives a birthday present, that may not be. Educational materials and missions, if any of you, we're contracted by the city, but we offer a seminar every other year. The invitation to that seminar is exempted from the Gift Ban Act, even though we may have food at the seminar, but it's part of an educational mission, or it's an educational, their provision of educational materials. And travel expenses are typically exempted from the Gift Ban Act. There are monetary limits that are also set forth in the state statute. There are exceptions of up to $75 per day. So there, and then less than $100 total from any prohibited source. If the gift exceeds $75, then there is a provision which, Marcus, are you taking this one? You can get into to talk about what happens if you exceed the limit. So I'll turn it to you for Evanston.
So Evanston's gift ban ordinance is set forth in section 110.6, and it follows the Illinois Act closely, but it does have a few departures. One of the things Steve highlighted was that intentional language. The Evanston ordinance does not have that language. It is as follows. No covered person shall directly or indirectly solicit or accept any gift from any prohibited source. And so the implication there is that you can't say, I didn't mean to accept this gift from this applicant, or I didn't know that this person was submitting an application to the city when you accepted that gift. The Evanston ordinance, as you see, goes a step further and has stricter requirements. So what happens when you accept that prohibited gift? 110.6 subsection D regulates or governs what you can do once you've found yourself accepting something you should not have accepted. And you have two things you can do. You can return the gift to its source, or you can donate that gift to charity. That is how it's set forth as well in the state statute. However, again, Evanston goes a step further. In addition to returning or donating that gift, and when I say donate, you can donate the gift or you can donate an amount equal to that gift's value, you also have to submit in writing disclosure to the special counsel. And you have to inform the special counsel that you've received the gift, that you have either returned the gift or you have donated the gift or appropriate value to a charity. The charity has to be a 501c3 exempt organization. And if that disposition is by donation, appropriate documentation must also accompany that written disclosure.
Let's move on to conflicts of interest. First, just pause briefly on incompatibility of offices. And our deputy city manager is not here. I was going to exonerate him and let him know why he's perfectly lawful in his position. There is a general state statute that prohibits the holding of two offices concurrently. But there is an exception that's built into the statute, and that is so long as if there is no contractual relationship between the government that the officer is holding a position in with the government that the officer is holding the other position in. If there's no contractual relationship between the two governments, the state generally allows the concurrent exercise of two different offices. That frequently we have come across situations where a member of a local city council or village board would want to also run for state office, state representative or state senator or governor. That could be an issue. It has occurred, but it could be an issue, in our opinion, because there are instances where there are contracts between the city and the state. In our opinion, that would be a contract between two governments, excuse me, that would prohibit that concurrent and it would therefore be an incompatible office. Any questions on that? We just wanted to briefly cover that. Let's move on to the other kind of conflicts of interest, And that's under the Public Officer Prohibited Activities Act. And let's talk about, and we're getting into this whole subject of conflict of interest. And it's a big subject, and we get it, we deal with it with our governments all the time. There's a statutory conflict of interest, which is under this Public Officer Prohibited Activities Act, and then there's common law conflicts. I'm going to start with the more serious one, which is a conflict that would occur under this statute. And that is if any officer is financially interested in a contract or the performance of work in the making or letting of a contract with that officer may be called upon to vote on, then that officer does have a statutory conflict. Let me put it another way. If you're an officer of a municipality, you cannot vote on or be part of a vote or sit on the council that votes on a contract with an entity that you have an interest in. And interest is defined under state law as having a substantial interest. If you're entering into a contract with ComEd or AT&T and you have hold some stock in that wouldn't be considered to be an interest. But if you do have an interest, let's say it's a company that you're the president of or a company that you own or control, the issue here is that it's not good enough to simply recuse yourself. You have two options. Resign from the city council or not have that contract be approved by the city. In other words, have your company withdraw the contract. There is no recusal if you have a conflict under this state statute. And I think that that's an important one. Most of the conflicts that we deal with and that you all deal with are common law, which we'll describe a little further. But I wanted to set that out. That state statutory provision is significant. And believe it or not, we have dealt with, and we're dealing right now in another town with this situation. And there's no choice other than resign your office or not have the contract proceed. Brooke?
And just to clarify that, Steve, sometimes we get questions about whether being an employee of a business is a sufficient interest to trigger this statutory requirement. And generally the answer to that is no. So
own or control the company, and if it's a publicly traded company, it's having an interest of more than 1% of that publicly traded company.
I just want to interject. I know that some folks have their hands up. Because the last question period went so long, we're going to have to hold questions till the end. So just ask council to hold all the questions and we'll let you go through the whole presentation.
Thank you, Mayor.
I just wanted to add too that there is kind of a third option, which is not, instead of not entering into the contract or resigning, the other option is to divest your interest. So you could, which is also an extreme option. But.
Actually, let me start with common law conflicts, and that's the more common approach where there may be a matter that you've been interested in, or your best friend is the head of the company, or somebody that your kids are friends with, or have a variation or a special use before the city. Those are all common law conflicts. Yes, they are resolvable by recusing yourself, but as a general rule, and this is what we advise as a general rule, these common law conflicts should be resolved in favor of allowing the council member to participate. It may seem incorrect to you, but the philosophy is you have been elected by the people for really the sole purpose of legislating and voting. It is understood that you are being elected in a relatively small town, and I say relatively, Evanston's larger than many suburbs, but a relatively small town where it is likely that you will know somebody or you will be interested in some matter or some activity. That is understood. It is accepted that as an elected official, you should have the ability to vote with a clear conscience and without regard to your predisposition or your knowledge of the individual or your friendship with if you've been invited on somebody's yacht years and years ago. I'm not talking about concurrently because that may be a gift ban issue. But it is expected that you will be able to cast a clear and impartial vote on the matter. Now, some issues may rise to the level where they are indeed a conflict, and there is the appearance of impropriety, in which case recusal would be the proper action. And recusal would be allowed here, and recusal should not only mean recusing from voting, but also recusing from participating or deliberating. It can't be that if somebody determines that they truly have an inability to cast a fair and impartial vote, that they participate in the entire dialogue and then say, I'm not voting. Further, if they're not voting or not participating, they should leave the dais and leave the room. They shouldn't be there to show the other council member by some look on their face that they should be pressured into voting one way or the other. That's our general advice. And Brooke, you want to bring it down to Evanston's specific rules?
Sure. So Evanston's municipal code largely incorporates and codifies the state law and common law conflicts rules in section 110.4. But one interesting Evanston specific requirement is in the section before that, in 110.3, which the purpose of this, I think, is to just sort of head off some of these anticipated conflicts. So in Evanston, elected officials and including staff that may staff employees that may staff a commission or a board need to disclose interests in business or in real property, like, real estate within the city. Obviously, there's a lot of other conflicts that you could have, but those are really specific disclosures that you have to make upfront on an annual basis so that everyone's just aware of those. In section 110.4, there are some additional sort of Evanston nuances that are provided that go beyond the state law. One of them is there's a section that requires impartiality from city staff, from employees. And it requires that employees provide city services without bias. So they can't provide a favor or a benefit to someone that's not globally available to every applicant or person seeking that service. And in addition to just having an interest in a contract of the city, the code similarly kind of creates a conflict of interest rules about city approvals. So that includes having an interest in a zoning approval or a building permit approval anytime the city's sort of taking action to grant some type of approval. And in addition to having a conflict, if you have an interest in a current approval, it also prohibits an elected official from gaining an interest in something where they should have known there would be an approval coming up. So where you would have had knowledge or should have had knowledge that you would have to take action on that issue in the future. These are treated like common law conflicts, so you can disclose them, abstain, and recuse yourself to cure that type of conflict.
Brooke, let me just also point out, there are other specific statutes that apply on a case-by-case basis. For example, if you're doing a TIF, tax increment financing, there is a prohibition from having any elected official from having a residence within the TIF district. We're not getting into those specifics. We're trying to keep it at your code level. Your attorney will counsel you when a certain specific matter comes before you.
We also wanted to highlight a section of the Evanston Code that's unique to Evanston, and this is a provision that's titled official misconduct. And this section prohibits a number of types of behavior, all sort of getting at an abuse of office type violation. So it's soliciting or accepting bribes, essentially, or using the prestige or power or influence of your office to obtain a personal benefit that's incompatible with your official duties.
Let's pause on that one, because that's a unique to Evanston provision, and I think one that's important. It's very well drafted, and it's intended truly to be an abuse of power, as opposed to simply being legislators. You can argue passionately about a position that you believe in. You could make that argument passionately inside the city hall, outside the city hall, to the manager, to one of the department heads. That's not necessarily an abuse of power. An abuse of power would be to say, I'm going to see that you're fired unless you agree with my position. But making a passionate argument about why an approval should go forward, a development should go forward, a permit should be issued, that is different. That's not an abuse of power. That's actually using power.
Right. I think that an example of the abuse of it would be, attempting to wield your position, like an influential position, to get a personal benefit. So to, try and get a reservation at a restaurant, or, which is a really minor example, but,
Out of a parking ticket.
Right. Just say, who I am, or you show them your city badge to see if you can get out of it. Or to pressure a city employee to issue a permit that would not otherwise be issued to just an ordinary resident, or at a different time frame that would not be available to another resident.
Mr. Mayor, I have a very quick question about this.
How much longer is the presentation, guys?
We have 5 minutes.
Yeah.
So
I will hold it.
Let's hold everything until then. Great.
Okay.
So just to note that a couple of the other provisions of this section, one of the other interesting and very Evanston specific, in the sense that not every municipality has this spelled out in their code, but one of the provisions is disregards their fiduciary responsibility. So obviously, just generally, that would mean that you have the best interests of the city and the public in mind when acting in your official capacity, and that you would be doing something in conflict with that duty. But Evanston Code then gives a very specific example, which is the disclosure of confidential information to the public without unanimous approval of the city council. So that's a very specific example that may have otherwise not necessarily been interpreted to fall into this provision necessarily, but it's worth noting.
And I want to pause on that one as well. There is a fiduciary obligation, even if this provision didn't exist or weren't so carefully stated. It has been determined in Illinois that members of an elected body do have a fiduciary obligation, particularly with respect to confidential information that you may receive through attorney-client privilege, or confidential information that you may obtain during a closed session, a legitimate closed session of the city council. You are obligated, just under general Illinois law, as pursuant to your fiduciary obligation, not to violate that obligation by disclosing or disseminating that information that was obtained solely and exclusively in a confidential manner. What Evanston does is take it one step further and makes it a violation of your ethics code, in addition to a general violation of fiduciary obligations.
Just to point out, I don't think we have time to get into sort of super specifics about these two provisions, but we wanted to make sure that you're aware of them. Is Evanston's whistleblower protection ordinance, which is in section 110.7, which in essence prohibits retaliation against an employee or a covered person who cooperates with, discloses, testifies, or otherwise participates in an enforcement proceeding regarding a violation of local, state, or federal law. So pretty straightforward. And the second one is, and just again, this is just worth noting since it's a very specific Evanston provision, which is Evanston has a code provision called abuse of code of ethics, which makes it a violation of the code to intentionally and in bad faith make an allegation or a false report of a violation of the ethics code.
So now, Mayor, before we conclude, and it looks like we're going to have some time for questions, and we're happy to answer them, we thought we'd just go over with you the process for enforcement of ethics complaints. I'm going to ask Brooke to do it. Those of you who have been involved or filed ethics complaints have seen Brooke's name on it. She's the individual in our office who is processing them. She's most intimately familiar with the code, and I think she'd be best to go over the process. So take the next slide. And
we just wanted to give a quick overview of just the general process that the code provides for handling what the code defines as formal ethics complaints. So once a formal ethics complaint is made, it's transmitted to our office as this special counsel, and we review the complaint. We review any relevant information, and we may even seek out additional evidence from the city, including body camera video. We'll watch whatever proceeding may have been at issue, the recorded video of it. So we'll seek out whatever evidence is available and perform an initial investigation into the allegation. Bear in mind that what we're looking for is whether or not the allegation in the complaint provides sufficient basis for us to move forward with a violation of the ethics code. If we find that there's not sufficient information or evidence to move forward with a violation of the ethics code, then we issue our determination, and that's sort of the end of our role in the process. If we were to find that there was sufficient basis to move forward with a violation of the ethics code, we would prepare a written determination, and then the next step would be to have an administrative hearing where the city of Evanston basically has decided, through our determination, has decided that it's appropriate to move forward and prosecute a violation of the ethics code, basically issue a citation to whoever it was that may have committed the violation, and prosecute that violation in front of the hearing officer. The hearing officer's decision is then moves forward to the Board of Ethics, who reviews the hearing officer's determination and can either affirm the hearing officer's determination, reverse it, or reverse and remand back to the hearing officer for additional proceedings. And if there is a determination that there is a violation of the ethics code, presumably there would be an entrance of a fine, which we can mention, but there is a penalty provision where a fine of $100 to $750 is the penalty for a violation of the ordinance.
Okay.
So that's the basic process for that.
There is our presentation. We are happy to answer questions on any of the matters we covered today.
Thank you. Are there any questions from council members?
Yes.
Councilmember Reed, followed by Ravel.
Yes. Thank you. Yes. I'll just go to the last one first, and I suspect some of my colleagues will ask what my first question was about the abstentions. But as far as official misconduct, if a council member were to list, for example, on a job application or a scholarship application, I did not list this on a recent, but on a scholarship application, for example, or a job application, that they were a council member, would that be a violation of the official misconduct, or could that potentially be a violation?
Do you mean like listing it as part of their like CV, like to just give their experience? Sure. No, I don't think so in general.
Yeah, I would agree. It's a fact.
Okay. And then lastly, the incompatible offices. Could someone serve on, for example, a park district and be a council member, or serve on, so you're saying as long as there's no contract between the city in that unit of government. What happens if a contract develops between? Do the offices then become incompatible, and
Yes.
you must select one of the two?
That is exactly what would happen, Councilmember Reed, that you'd have to choose one or the other before that contract was approved by either side.
And if it's approved by either side, then you just forfeit both offices, essentially.
Or the contract could be void.
Or the contract could be void. Okay, thank you.
Councilmember Revelle.
Could you speak about council members' involvement, let's say in a nonprofit organization that is coming to the council for either funding or zoning change or something? If the council member, I think our ethics code doesn't allow us to be a board member of a nonprofit. Anyway, board member role, major donor role, et cetera.
It could fall under the state level, which would prohibit you from being part of that organization, or it could, if you really are a member of a not-for-profit, but don't hold a controlling position or a leadership position, it may then fall under just the common law, where recusal would be sufficient.
And this would apply if you were a major donor, for example, as well?
Yeah, if you're a major donor but not in a leadership position, then it could very well, certainly not. I do not see that would be prohibited under the State Act, and you'd have to determine under the Common Law Act whether you would have it creates the appearance of impropriety, or if you are unable to make a clear vote on the matter. I would generally advise recusal.
Okay, thank you.
Clerk Mendoza, followed by Councilmember Heracariz.
What about non-voting members who are part of boards, but the organizations that partner with the city?
So it would probably fall into as a clerk or an employee, the regulations are generally the same, but you're not voting on it, so you don't have the ability to recuse. So it's an excellent question. Let's see if there's something specific. I'll give you the answer on a general municipal law answer, and then Brooke's going to look for if there's anything specific. There is no ability, if you're not voting, there's no need to recuse or not be part of the deliberation. In fact, there's an Illinois law that requires a clerk to be part of every proceeding of a city council. So I would say that there's no ability for that clerk not to be present, and there's certainly no issue about voting because the clerk isn't voting one way or the other. It falls into a very different position than the members of the city council. And I don't know if there's any, that's my general municipal law. I don't know if that's in.
Yeah, I mean, the specific, where it would apply is if your position on that nonprofit for some reason would give the appearance or would actually conflict with your ability to do your job with, impartiality or with fiduciary duty to the city. Now, I think, volunteering with a food kitchen or being on the board of a local theater company or something would not rise to that level probably ever. But there may be, I guess, circumstances where that there's a direct conflict somehow in the interest between those two organizations that would make it so that you couldn't do both, essentially.
I fall back on the general proposition that you all, the clerk as well as the members of the city council, are residents of the city of Evanston. There will likely be a situation or a circumstance that you're involved in that may be considered by the city of Evanston. It is not axiomatic that you cannot vote on that. In fact, as I said earlier, it's probably expected or that the clerk can sit in during that meeting. You're engaged people, and it would be a bigger issue if we leaned toward recusal all the time, because then you'd have an issue getting a quorum or enough votes to pass anything. And that's in many ways a bigger and more concerning an issue than the appearance of a conflict in the first place. That's the way we've looked at it in my years of practice.
Councilmember Heracles.
Could you speak a little bit to the situation about having your employer do business with the city? For example, I work at Northwestern, and how that works in the voting.
Yeah, specific to Evanston, I don't know that there's enough of an interest as a mere employee. Unless, again, you'd have, so I don't think it would qualify for prohibition at the state level. So anytime Northwestern would have a contract with the city of Evanston, I don't think Northwestern would be precluded, and I don't think a resignation from office would be required. But if there's a specific matter that may benefit you specifically or your department, I don't know where you are at Northwestern, but in a specific department, okay. Approval of a specific building, that may create the appearance of impropriety, and it may be something that you may want to consider recusal.
Yeah, because I think when I spoke with corporate counsel before, they said as long as it's not directly affecting my job, so.
I think that was good advice.
Are there any further questions? Councilmember Kelly?
So I wonder if you could talk just a little bit more about the Board of Ethics, because I've had people ask, well, they never meet. And so just to be clear, they can't, I mean, no one has any clue as to what's going on because of this new system. So have there been complaints, or in like how many ethics complaints?
Formal complaints?
Yeah, if you've received any, since
we have received formal complaints, I believe 6, maybe 5 or 6 formal complaints. We have not found that there was cause to move forward with a hearing on them, an administrative hearing. So they have not, so since we have been special counsel, there's been no complaint that has gone to an administrative hearing that would then go before the Board of Ethics.
Okay. So there's several layers before it would ever get to the Board of Ethics, so they haven't heard any complaints. If a complaint were to arrive to the board, they cannot further investigate, correct? They just basically stamp it up or down.
They would review the record that was created during the administrative hearing and determine whether, basically, that the hearing officer decision was backed by the manifest weight of the evidence. So they're really reviewing on the record.
So they're agreeing or disagreeing, but there's no further investigation, right?
They're set up to act as, and lawyers would understand this as in an appellate authority, where they review.
So is it, and also just to understand, so we currently, the wording of our ordinance precludes them from even meeting, even like to educate the community, because that's one of the benefits of a ethics board, is to be able to provide seminars and educate the community around governmental ethics. So currently it says that they shall not meet unless unless one of these complaints has made it through both of these layers. And I just question, even the legality of precluding a public body saying that they're not allowed to meet. They've only met because state law says they have to meet in order to review minutes, executive minutes. So, it seems to me that should be changed, no? That they're not even allowed to meet unless a complaint ever makes it through both of those layers.
I'm not sure. I'm sorry. I'm not sure it says that that the language is written in that construct. It does say what their powers and duties are, and their powers and duties are limited to reviewing the decision of the administrative hearings.
You look at the description of meetings, or I'll pull it up. It says there's like 2 sentences under one section that says they shall only meet.
Right. And I think that's because under their powers and duties, they have a very limited set of powers and duties, which is they're authorized to, they are created to review the administrative hearings decision.
Let me also, we're here simply to let you know what your code says. This is your code. This is your, this is not a state mandated requirement. Evanston has its its Board of Ethics by virtue of the city council creating it. And those are the rules that go along with it. I see nothing inappropriate if that's the rule that the majority of the city council so desired.
Okay, so I guess that's my question then. A public body, it can be they can be precluded, they aren't allowed to meet. We can make really so that they aren't even allowed to meet.
Those are the parameters that you, the city council, created when you created the public body.
Okay, so I don't think we were aware of that when we made it, but I think it's a little awkward because they're three people, so they can't even speak because they would be a majority of a quorum.
About their specific role. They're entitled to speak together about anything else.
Right, the weather. Thank you.
Well, thank you very much.
Okay. Again, Mayor, thank you for the opportunity. We hope you found this educational. We're here to help, and we're glad to have provided this. We'll work with the Deputy City Manager and Megan to make sure that this is available to you and other council members that weren't here. Again, thank you for the opportunity to serve Evanston. We really appreciate it.
Thank you. We now return to public comment. Those who hung around online will be called on. Each will be given 3 minutes.
Sorry, I have one last question.
Oh, Councilmember Burns, sorry, I didn't see your hand up. Go ahead,
I just put it up. It was something around gifts and $1,100. Is that in a year's time? Is that, what is that? Explain that for me so I can get it.
So under Evanston's ordinance, there's a cap of $100 gift. That is, and for the year. So if you do $49 early in the year and then $50 later on in the year, you have not gone over that that cap. If you add just $2 more before the end of that year.
Evanston, let's just double check, make sure we do. Is it a calendar year or is it in a 1 year period? I've dealt with this before when someone looks at just a two-nighter or a party that extends past midnight. It's either they can get to the full 200. We've seen it all, and so let's just get you the exact language from your code. In a single calendar, so it's in a single calendar day. So you're even more restrictive than general law. Right. Is that where the $100 is? No, we're. Yeah, so Evanston is $100 in a single for food and refreshments served and a single calendar day. You default to the state code, which is $100 in a single year for all other types of gifts, calendar year.
So if we receive more than $100 in gifts in a calendar year, we have to report that.
What
you're saying?
There's the various procedures that Marcus went through that steps you'd have to take. And from a single source. And it has to be from a single source. That's a good point. Not from multiple sources. They're not. It's not.
And then, so where did I hear the $1,100? Is that what the state? I misunderstood that. Okay.
Yeah, I don't think we said 1,100.
Okay. All right. Thanks.
Sure we did. Okay.
$100 from a single source in a calendar year. Over that, we have to go through the reporting.
The reporting or the divestiture or the charitable contribution. That is correct.
Okay. All right. Thank you.
Okay.
All right. Thank you once again.
Thank you.
So we return then to our public comment where speakers will be given 3 minutes. We begin with Hallie Rosen, who will be followed by Kathy Rospenda and then Nick Davis. I see Ms. Rosen is.
I couldn't even though I've been on Zoom for how long, I couldn't figure out how to unmute myself.
None of us can do it. None of us can do it.
Anyway, let me get my notes. So my name's Hallie Rosen. I live in the 7th Ward, and thank you, Mayor Biss and everyone on the council for your work in recruiting a new city manager. I know that it's been a difficult process. Thank you for an opportunity to share my concerns. I hope that the council realizes that Evanston citizens expect a city manager who is enthusiastic and experienced in anti-racist work in their current job and who has a record of welcoming and being responsive to public input and of building trust with residents. Any candidate with a record of being hostile to racial equity work or to public transparency and input will not be a success in Evanston. Such a choice will result in yet another failure and a need to restart the process once again. If the finalists do not meet our expectations of a collaborative, anti-racist, trustworthy public servant who embraces working with the public, this will be seen as a betrayal and deception on the part of the council and the mayor. You will have lost our trust. I don't feel like the city is in a crisis. Luke Stowe is an excellent choice for interim city manager, and we have a huge staff with qualified and experienced department heads. There's no reason they cannot make major decisions and hires. Kelly Gandersky hired both a new HR director and a Parks and Recreation director, and I had every confidence in her authority to do so. And this will continue to be the case with Luke Stowe. Thank you.
Thank you. The next speaker is Kathy Rospenda, who will be followed by Nick Davis and then Carlos Sutton.
Thank you. Hi, this is Kathy Rospenda. I live at 2101 Payne Street in the 7th Ward, and I'm commenting also on the city manager search. As someone who is responsible for hiring and managing staff, and I'm sure, I'm being asked to start my video. There you go. I'm sure many of you have experience with this in your paid employment as well. I can understand and relate to council member fatigue with the search process and the desire to just get someone in there already. But have you ever experienced how difficult your job can become after hiring someone out of desperation? If so, I hope you'll reflect on that experience before deciding to just appoint someone to the city manager position without getting the public input to the process that residents have been calling for. We need a city manager who is open to seeking and responding to public input and establishing transparency with the Evanston community. It's my understanding that despite our community's repeated calls for information about and input into the hiring process, interviews have been happening once again without public input, and only a single candidate may be put forth. This is especially concerning in light of today's editorial in the Chicago Tribune, and it's making it feel like it's a foregone conclusion that we're only going to get one candidate for the city manager search. I urge the council to take a different path and commit to a hiring process that has public participation and transparency, and which centers anti-racism and equity in the job description. Any candidate with a poor record in this area will ultimately fail in our community, as noted by prior commenters, and hiring such a person will further chip away at the trust community members have in our government. Evanston deserves a city manager who's committed to and experienced in anti-racist work, as well as committed to public transparency. Residents deserve a city government that they trust to listen to their concerns. I hope you'll do so this evening, and thank you all for your time and for your service to our community.
Thank you. The next speaker is Nick Davis, who will be followed by Carlos Sutton and then Doreen Price.
Afternoon, everybody. I'm here to address the position of city manager as well. I got a lot, so I'm going to talk kind of fast. But so John Fournier, the most recent candidate to withdraw, had allegations of race-based discrimination with other unfounded allegations. And similar to the city manager position here, his former position in Ann Arbor was replacing a predecessor who also faced racial discrimination charges, much like our city managers have here. So Evanston and the search firms have been contracting or continuing to represent or present candidates with the same problematic background that we say we're trying to move past. And so just to remind folks, before Luke Stowe, who I have nothing to say about right now, right, was Kelly Gandersky, who I personally witnessed act dismissive, condescending, and apathetic. towards council members, community members, and organizations who raise concerns over police powers, of which are granted through contracts that she helps negotiate or helps to negotiate with EPD's labor union. She also shared responsibility with some people who are currently in city government for rehiring Chief Eddington, in spite of his implementation of stop and frisk-like policies and the mishandling of several racially motivated crimes by EPD, which included the $1.25 million settlement awarded to Dr. Crosby after he was beat for allegedly stealing his own car. None of the city managers since then have enacted any disciplinary actions against those officers. Anthony Carrera, Brian Hicks, Sean O'Brien, and Ivan Reza, who also work for EPD, some who've been promoted, and they're all slated to make over $100,000 from our taxpayer dollars during this 2022 year. Prior to Ganders, we had Storley, who I don't think I need to repeat the largest scandal under her because it happened so recently, but she was replacing Wally Bobquist, who also was allowed to leave after having $500,000 of taxpayer dollars get paid out in a settlement for his own racial and gender-based discrimination lawsuit, which he was at the center of. It wasn't even like why I know this was happening. It was directly addressed towards him, right? So we now have a history, if we didn't already, of non-elected city managers who are allowed to be at the center of or be oblivious to violent forms of discrimination that are being enacted against our own city employees and our own residents, right? And in some cases, visitors as well. And it's just our tax dollars who are being allowed to cover up for this. None of these people have received disciplinary action from the city in the past, nor I doubt they'll face it in the future. And the recent editorial board article published by Chicago Tribune now is addressed in the last comment, alleges that Evanstonians' abundance of opinions and our desire to be included in city decision-making processes is to blame for the challenge we've had during these searches. But given the last mayors we've had, I think we should be asking for more decision-making power, more transparency, unless people don't think that racial and gender-based discrimination is a hindrance to true democracy. I know there's been a kind of a political shift recently where for some reason people think that elected officials aren't above critique. I'm sure you all are not feeling that in Evanston, but in the wider political arena there is, correct? And blaming citizens for wanting to be a part of a process that ensures people who are representing us have the backgrounds that are reflective of what we want, and blaming us for it, in my opinion, is kind of cowardly and in direct opposition to what almost everybody in this council ran for when they said they were in favor of more transparency and public support. So if Evanston truly wants to be the most livable city, which we put out there everywhere in every public statement, we can't keep having public servants who are afraid of us and get so defensive in the face of our critiques that they can't make substantive change. Sorry, thanks for letting me go over time.
Thank you. The next speaker is Carla Sutton, who will be followed by Dorian Price.
Good evening. I want to thank you for this opportunity. Carla Sutton, resident of the 5th Ward. I have two concerns from the presentation of the ethical. I think it's very unethical for the city to pay developers to come in here and to make presentations about what should be developed in the 5th Ward TIF. When we as the citizens have established and the city has voted for the things that we said are most important to us, and especially as Black residents, and are remaining in this city, and especially in the 5th Ward. I'm also concerned that at this time that we are not having adequate input into what our concerns are, and that we have no other place to go. I'm also concerned that the ethical committee is more of a committee of just talking without anything that they can do to take any kinds of stands or reprimands from people in the city who have done unethical things. Thank you for the opportunity. I appreciate it.
Thank you. And the final speaker will be Dorian Price. Ms. Price, are you able to unmute yourself?
Yes.
Oh, great.
Yes, thank you. I am wholeheartely in support of what the three previous speakers had spoken about, and especially the strength of the arguments behind them about not making something urgent for the sake of getting something done as in terms of what it represents. And the fallout of having to live with a bad decision we've witnessed, as really beautifully illustrated what Nicholas Davis said, and also what Carla Sutton said. And so what I'm saying, hopefully, is taken in that context as well, which is very powerful. And so I say, who wouldn't want to lead Evanston forward? And this is my public comment, 3:52 tonight. Regarding the Tribune versus real glossed over failures, good journalism must vet departing accolades, which we've all seen for all the city managers that have gone before, meant to deflect lawsuits. What happened in Chicago happens in Evanston too. Residents that lawfully pushed back based on serious experiences and evidence are not to blame, which we've seen in print too. Today's status quo began with City Manager Wally Bobowitz and his political successors. Try living your life on social good promises that got lost in austerity and firing of a nationally recognized public health director with grant money to help people as priority budgeting. How could that be? Nationally, we're in prolonged social-economic crisis dependent on the status quo that prolongs community need for repair, inclusion, and reconciliation. Our hearts can do much better than spreadsheets relying on silos that exclude synergies and opportunities. Expediency must not justify an unacceptable and harmful status quo for the many, both pre and post-COVID. Create or expand programs to better reflect Evanston's professed values, but fall way short. Why? Lives are at stake. When will ARPA funds meant for taxpaying homeowners and residents address social and economic inequality and preserve diversity directly? Narrow slivers, limited prototypes, inadequately funded and overwhelmed charities delay inclusive community recovery. ARPA funds were not meant to be a lottery to help the few and exaggerate existing trauma. ARPA is a serious funding for resiliency to restore sustained community-wide prosperity, vitality, and well-being with urgency. What new city manager wouldn't be excited to lead and support seniors aging in place with peace, wisdom, and naturally occurring affordable housing for community-wide well-being in our WHO designated city? Perhaps the type of city manager who would seek, yes, thank you. Perhaps the type of city manager who would seek out and excel at this role merely needs our city council and mayor to public embrace the same with the same heart, passion, and urgency. Thank you very much.
Thank you. That concludes public comment and brings us to call of the wards. Councilmember Burns.
No report.
Councilmember Ravel.
No report.
Councilmember Reed.
No report.
Councilmember Hedekaris.
No report.
Councilmember Kelly. No report. Councilmember Wynn. No report. Councilmember Nusma.
No report.
And now, seeing nothing further to come before us, the July 18th special meeting of the Evanston City Council stands adjourned.